Under the Code of Criminal Procedure, Chapter 17, is the authority on surety bonds. Article 17.02 defines a surety bond as a contract between the arrestee and the surety. A magistrate judge may authorize the arrestee be released with a PR bond under Article 1703. This is the most common way to get out of jail. On the other hand, Article 1704 specifically sets out that no surety is required. Similarly, Article 17033 clarifies what will happen in the case if there is no probable cause found by the magistrate with 24 hours of arrest for a misdemeanor. It explicitly states if the arrestee is unable to pay cash or surety, then he must be released on a PR bond. In addition, a judge must release a person under a personal bond if he similarly cannot afford cash or surety for a felony, if the judge has not found probable cause within 48 hours. Article 1705 states the jail can accept the surety bond. Article 1706 states that corporations can be surety, securing the bond obligation for the court. Article 1707 specifies that the surety bond company shall file their power of attorney naming who's in charge of posting bonds. They are allowed to limit the scope of their authority as with any other power of attorney document. The law reiterates that any surety bonds posted by the bail bondsman are binding on the surety themselves. Rarely are there redundant provisions in the law, but they wanted to make it crystal clear this is a very serious legal matter. Article 1708 states the requirements of a surety bond. First, it must be made out to the state of Texas. Second, the arrestee and the surety must promise the person accused will go to court to face the allegations against them. Third, it must state what they are being charged with, a misdemeanor or a felony. Fourth, the surety must sign the bond and jot down their address. Fifth, the law states the bond must state the courthouse and the court date when the defendant must appear. It's nice to say that when the case is closed, either by conviction or dismissal, the surety is dissolved from their responsibilities. Lastly, the statute states that if the arrestee doesn't show up to court, then the surety needs to pay for the sheriff's and police officers the fair cost to rearrest the delinquent defendant. Article 17.9 protects a defendant in the course of their case from excessive bail. This is common among lawyers who advocate in court for decreasing bail for violent offenses. The main argument is that similar cases has had lower bond amounts, or other cases were less serious and had lower bond amounts. Or lowering bond would still secure the defendant's appearance in court. Or the arrestee is not a flight risk. And he is not dangerous to the community. The judge in the case is very powerful in this respect. Additional safety measures prevent a second bond amount to be required for one case. This makes sense because it would ride the line between cruel and unusual punishment, even in the pretrial stage. Article 17.10 lays out the requirements on who can be a surety. You must be an adult who has not been convicted of a misdemeanor involving moral turpitude or a felony. A crime of moral turpitude can be anything related to theft or fraud. It implies that someone is dishonest with money and can't be trusted for important financial matters. Article 1711 expands on what is required for a surety. It says that your assets must be worth at least twice the bond amount. And it says you can't write any additional bonds if you're in default with at least one bond. This is a very fair rule if you think about it. A bank wouldn't allow a borrower to take out another loan if they can't even pay the first mortgage. In the same line of reasoning, they are requiring the surety that they don't owe the county anymore before they can take on more debt. Article 17.13 requires sureties to take an oath promising they can pay the entire bond amount from their own property if it comes down to it. And Article 17.151 is the defendant's best friend. This guarantees them the right to get out of jail if the government is not ready to proceed to trial. The judge must first reduce the bond amount required. And if the person can't afford that either by paying themselves or through a surety bond, then the judge must release them under a personal recognizance bond. This is very powerful indeed and reflects the power of the person's right to a trial under the federal Constitution. For a Class C misdemeanor, the time limit is a week. For a Class B misdemeanor, the time limit is half a month. For a Class A misdemeanor, the time limit is a month. And for a felony, the time is 3 months. Of course, other offenses currently charged are taken into consideration, and all pending charges must qualify for pretrial release. Article 17.16 lets the surety off the hook if they get the defendant to court or to the county jail. If the arrestee is in another county jail, then the surety must file an affidavit to the sheriff's office and to the prosecutor's office, telling them the accused is in outside custody. However, detention by Immigration and Customs Enforcement does not qualify if the sole purpose is to decide whether the defendant is a lawful U.S. resident. Once the jail verifies this information, they must tell the judge, who in turn is required to issue an arrest warrant, commonly known as a capias. However, the surety must pay for all fees associated with transportation of the defendant back to the local county jail. Article 17.19 also allows the surety to file for a warrant with the court. This is what allows bounty hunters to get people back to jail, something normally the only sheriff's office has the right to do. Citizens' arrest is also a related topic that is making headlines, especially after the Ahmaud Arbery shooting by a former investigator for the district attorney's office. During magistration, the judge can set any conditions of bond they see fit to protect the community and to ensure the defendant appears for every single court date. And if a condition is violated, Article 17.40 provides that the violation only needs to be proven by a preponderance of the evidence, or more likely than not. Once the judge finds the violation occurred, the surety bond will be revoked, and an arrest warrant will be issued right away, most times for double the original bond amount. After the accused is back in jail, the surety is relinquished of any liability at that point. This is a sneaky way for them to charge the defendant's family again for another surety bond all over. Repeat customers is the dream for any business.